The next case on the call of docket this morning is agenda number 17, 126748, Jill M. Bailey, individually, and Mercy Hospital Medical Center et al. I understand that councils will be splitting their time, and you're Mr. Streckley, and Vivian, Therese, Trevor, Fernando. Okay. And then Mr. Walsh. Okay, you may proceed.
Ms. Tyler Bernardo, Mr. Strzelecki. Good morning, Chief Justice Burke, Justices. My name is Michael Walsh. I represent the appellants. In this particular case, it's 4 emergency medicine physicians, as well as EMP, their employer, in a medical malpractice case before you today. The issue in this particular case is whether the appellate court deviated or was wrong or incorrectly ordered that the judge in the underlying trial case abused his discretion by failing to give a non-IPI instruction and instead relied upon what has been relied upon for the past 24 years, the IPI long form 105 instruction on proximate cause. Second, we're here because the appellate court refused to give a modified, we're here before the court because the trial court refused to give a modified informed consent instruction. Third, we're here before the court because the appellate court erred in upholding a judgment for the hospital, even though there was allegations of apparent agency directed against the hospital for the acts of the agents and apparent agents of this particular case. Clearly, if this court properly reverses the appellate court on the first 2 errors, the third error is moot, and actually it's agreed upon by the parties. To get where we want to be, we have to go back to 1997. The Holton case on lost chance. Loss of chance has been held as a causation concept, not a separate theory of causation, as implied by the First District when they held in this case that it was necessary to give a non-IPI instruction on lost chance. That ruling by the appellate court is a stark departure from the existing law clarified in 97 by the Holton case, by this particular court. As this court knows, in Holton, the court addressed 2 divergent views in trying to harmonize causation issues. One of them was the Borowski standard, where the basis or the evidence on causation was by preponderance of the evidence more likely than not. Other cases before Holton had issues when the plaintiff expert could not establish that the patient would have survived more than 50% but for the negligence. So the survival rate was 50% or less. Those particular cases, like Curry versus Summer and Russell versus Subia, barred the plaintiff from recovery. The Holton court said that particular bar is inappropriate, and that's what launched loss of chance. The loss of chance theory is that if the plaintiffs cannot establish through their experts that the patient would have survived more than 50%, they're still entitled to proceed against to the jury, and that the diminution of value from the negligence is compensable. Holton, oddly enough, affirmed the Borowski traditional standard that was before them on proximate cause, and actually utilized 105 long form instruction on causation. The defendant had to prove that their negligence was or the plaintiff had to prove that defendant's negligence was more probably than not caused by the injury, but there was no need to prove a better result. Holton also held that the loss of chance concept is properly encompassed by traditional proximate cause instructions found in long form IPA 1501. Lost chance, per Holton, is not a distinct theory of causation. It's a concept that is encompassed in the 105 long form instruction on proximate cause. The court also noted that the loss of chance survival of less than 50% absent negligence should not be a bar to recovery. Specifically, this particular court held that although it may appear more difficult for a jury to assess exactly what harm and negligent treatment caused in context of a pre-existing illness or injury, those are the lost chance kind of cases, juries routinely are asked to decide whether and to what extent negligent treatment proximately caused the injury. That was 24 years ago, 1997. And since that holding and that ruling and that idea to harmonize the issues on survival rate, below 50%, lost chance, over 50%, Borowski standard on probably true than not true, cases have gone forward. And the juries have been instructed on these particular issues over the last 24 years.
The fact it's gone on for 24 years doesn't mean we shouldn't reevaluate it. Amicus for the plaintiff has pointed out 13 states that found it helpful to juries to be specifically instructed on this theory.
That is true, Justice. I agree with that. If it's going to be helpful for a jury, that's fine. 36 don't believe there's instructions, and a majority of the states did not adopt a particular instruction on loss of chance. But you're right about that. The issue with loss of chance is it needs to be specifically defined, and it has to limit recovery to the diminution of the value when a surviving plaintiff who has a less than 50% survival rate does not get a windfall with respect to damages. That is why in this particular brief that we filed with the court, a Dillon analysis might not be inappropriate in the subsequent IPI instructions that they came up with. But that's not the law for loss of chance when this case was tried in front of Judge Lyons in May of 2018. There wasn't a discussion of that. The IPI instruction applied to loss of chance. That's what has been held and has been held to this day. We've talked about cases where loss of chance has been addressed. Aguilera, Townsend, Reed, Scardina, Karnovic, even Jordan versus Loyola. All of those particular cases dealt with the issue of loss of chance when the negligence, or but for the negligence, the plaintiff would have had a less than 50% survival rate. Beyond it, you apply Borowski. You apply more probably true than not. And the burden is on the plaintiff to establish that.
But
But-
wouldn't the using of lost chance help the jury understand or consider the proximate cause analysis?
The applying a loss of chance would if the patient's survivability is less than 50% absent the medical negligence. So in those particular cases that we're dealing with, those are ones where patients have underlying medical conditions, where their survivability is 50% or less, and then a lost chance concept can be broached. But it's also been incorporated in 1501 already, according to all the cases that have come down, including Henry versus McKechnie, Lambie versus Schneider, Sinclair versus Berlin, Cetera versus De Filipino, that said there's no need to depart from our previous determinations of IPI properly stating the law on last chance. Vanderhoof versus Burke did the same thing. And while we were briefing this very case, Gretencourt Sobar versus Kokoska said the same thing. And in that particular case, the appellate court was addressed on whether Bailey was an error. And they sidestepped that issue. And that's now before the honors here to make that decision. Did the court err in ordering, holding that Judge Lyons abused his discretion by not giving a non-IPI instruction on lost chance when IPI 1501 long form was the law of the land? That's what was established. Finally, since 1997, Illinois Pattern Jury Instruction Committee has not done anything on whether to push this issue on specifically identifying what lost chance is, and more importantly, what lost chance is not. The concern on the defense bar and for physicians across the state of Illinois is because there's no caps in the state of Illinois, a finding of lost chance, a diminution from less than 50% to say 30% would allow plaintiffs unfettered damages. It needs to be defined. It needs to be limited. There was no abuse of discretion by Judge Lyons when he did not give that non-IPI instruction. He followed the law. He followed 1501 long form on causation. We request that you reverse the appellate court on that particular issue and affirm the defense verdict on behalf of my 4 emergency room physicians, an EMP, in the trial level, where a case went on for a month, 16 experts testified, and the jury came down with a general defense verdict for all defendants. Oddly enough, this isn't even a lost chance case that we're here for. Holton talked about removing the bar for those that cannot establish that there was a greater chance of survival. So that's going to be the issue. Is lost chance present if an expert cannot testify that the patient would have survived? More likely than not, more than 50%. That's Borowski. Less, lost chance. Is this a lost chance case? Such testimony on lost chance before was barred. Now it was open for the court to determine, and it would go to the jury. However, if the plaintiff experts are able to opine in absence of negligence, plaintiff would have probably survived greater than 50%, then the lost chance concept is not applicable. It's straight traditional negligence under the Borowski standard. The appellate court knew this. 24 years of precedence was ignored, and they ordered that it was an abuse of discretion that Judge Lyons did not give the non-IPI instruction. But this was not a lost chance case. The case involved in the underlying case is twofold. One, did Jill Milton Hampton die from a bacterial infection that led to toxic shock syndrome and caused her death? Everybody in the case agreed. Bacterial infections are treated with antibiotics. Or, alternatively, the defense position was, this patient died from viral fulminant myocarditis, which unfortunately this country has had to see for the last 2 years during this pandemic. A virus can kill. A virus cannot be treated with antibiotics. That was also agreed upon. So we have 2 diametrically opposed theories in this particular case. Plaintiff's experts opined, you give the antibiotics, more likely than not, Jill Milton Hampton would have survived. Their theory was premised on the presence of a tampon that was left in her vagina. Back in the 1980s, we had long discussions about toxic shock syndrome, what it was and what it wasn't. And in this particular case, the plaintiff, led by Dr. Harry Jacobs, a hematologist in Minnesota, said, tampon is the key. So how did they establish this? When you have a bacterial infection, you need to establish a nidus of infection. In other words, a source of the infection. And the source of the infection offered by the plaintiffs in the underlying case was this retained tampon. And what happened over time is that bacteria grows, it turns into toxic shock syndrome, and it can kill you. Time is important. You give antibiotics under those circumstances. Now, to establish this tampon is the key, they had a doctor by the name of Dr. Ralph Gobian, who was a South Carolina radiologist, opined based upon a CT scan that there was a tampon in the vagina. And there's your nidus of infection. And because of that, you delayed in treating this patient. And according to 2 experts by the plaintiff, Dr. Hilton Hudson and Dr. Harry Jacobs himself, said, if you had given antibiotics to this patient, even just before she coded, she would have lived. More probably true than not. In other words, survival more than 50%. Because of that testimony, we're out of lost chance. We're into the Borowski standard. And because of that, the defendant's response was as follows. This patient never had a retained tampon. It was never found on pathology, on the autopsy. And we had 2 experts come in and testify. Dr. Richard Gore, who literally wrote the book on CT scanning, and Dr. Yagme, chairman of CT radiology at Northwestern, that showed the jury the CT scans. Normal CT scans of the abdomen and this one. and they both said the same thing. Unfortunately, Dr. Gobian does not know his anatomy. He's looking at the urethra. He's not looking at the vagina. There is no tampon there. In addition, plaintiff was treated conservatively in the hospital on 2 occasions. She left, and we'll get to that issue with the informed consent, and came back. There was no tampon there. She did not have a number of ailments alleged by plaintiff, including a PE or a GI bleed. Her vitals were normal on the way up to the observation floor on the morning of March 18th. She wound up coding on the observation floor. So the issue before the jury was a simple one. Is this a bacterial infection that caused toxic shock syndrome, or is it a viral infection that attacked the heart? In order to help the jury even further, we grabbed Dr. Arthur Reingold, who actually sat on the CDC board back in the 1980s, who reviewed thousands of cases on determining what is the CDC criteria for toxic shock syndrome. And 2 of them are fever and rash. Patient had neither one. Patient was afebrile. Therefore, the jury wasn't talking about loss of chance because it didn't apply. The jury's decision was, did she die from a bacterial infection or did she die from a fulminant myocarditis? And the jury came down with the ruling that there's no deviations from the standard of care by anybody. They supported the defense of the doctors and gave a general defense verdict to all of the defendants in the case. That all being said, this was not a loss of chance case. However, if the court finds that there needs to be some sort of instruction in the event that the plaintiff has a less than 50% chance of survival in the absence of negligence, then we recommend that the issue be looked at and a Dillon type of analysis be applied with the Dillon instructions with respect to 30.0403 and 30.0404. Now, both of those are put in conjunction together, and basically they indicate that the instruction must be given together, but neither instruction is given unless the plaintiff is claiming damages that are less than 50% certain to occur. So if you're looking at a Dillon instruction on future harm issues, and that particular Dillon case talked about the retention of a catheter in the body that migrated to the patient's heart, and that patient had a risk of future harm between 5 and 20%, that's below that 50%, that kind of mimics the issue with respect to lost chance. The Dillon analysis talked about both lost chance and future harm have the same or similar underpinnings. So if you take a look at that particular instruction and how that's formulated, that wouldn't be applied in this particular case either. Because again, it's less than 50%. That's a less than 50% certainty case. So it still would have been a Borowski standard on this case. So even if we had that particular type of instruction, it wouldn't have been given. That's why such an instruction in future prospective cases may be helpful for attorneys like myself and my colleagues here and working up cases with respect to lost chance, when it should be given and when it shouldn't be given. As far as the other states across the country, Justice, less than half of the states have adopted a lost chance doctrine. 17 have rejected it. 26 do not recognize lost chance. And 35 do not require or have not approved of an instruction on lost chance. In this particular case, the non-IPI instruction, am I down to 3 minutes already?
3 minutes.
Oh, I'm sorry. The non-IPI instruction that was proffered was vague. It talks about if you decide that there was negligent delay in the diagnosis and treatment of sepsis. Unfortunately, there's 2 different types of sepsis. There's viral, there's bacterial. They're grabbing both theories and trying to persuade the jury inappropriately on the damages in this case. It's too vague. It's also not limiting. It does not have a limit or a cap with respect to the amount of recoverable damages. Informed consent. So that's my loss of chance discussion. Anybody have any other questions about loss of chance before I quickly jump into informed consent? Okay, informed consent. Plaintiff's counsel used a modified informed consent instruction, or attempted to, and the judge said no to it because it didn't specifically apply to these cases. Under informed consent, under the requirements, a patient gives consent to a procedure or treatment. The patient claims that consent was not informed because the physician failed to appropriately advise the patient the risks or alternatives of the treatment or procedure. The patient claims that if fully informed, he or she would not have consented to or undergone the treatment or procedure. You can see the recurring theme here. The patient is injured to the consented to treatment or procedure. The appellate court looked at the wrong instruction. They looked at 01, they didn't look at 02. Coriel, Welton, Davis versus Kraft, and even Doe versus the University of Chicago all talk about treatments and knowledge before a treatment or procedure is performed. That isn't the case here. Dr. Jones took this patient on at 3:30 in the morning. The patient was getting IV antibiotics. There was a urinalysis test result that came back a little after 5. He went in to see the patient at 5. She was sleeping. He came back in, and she's getting dressed, ready to go. She doesn't want to be there anymore. She's had enough. And he wants her to stay because she has a couple of abnormal vitals. He doesn't know what's going on.
Now is your time.
Okay, I apologize. So for that reason, I wish that the court would also reverse the appellate court's ruling that the modified informed consent that addresses procedures and treatments and not what happened here be ruled upon, and that this court find that defendants are entitled to their judgment that was given to them by the jury back in May of 2018. Thank you very much for your time.
Thank you, Mr. Walsh. Ms. Tarver Fernando?
Good morning, Your Honors. If it please the court, counsel, my trial colleague, Bob Strzelecki. Your Honor, I will quickly say there are 3 issues before this court, and then I would
You
address.
didn't say your name. Just
Oh,
for the
I
record.
apologize. Vivian Tarver Bernardo, on behalf of the appellee
Thank you.
and plaintiff. My apologies to the court. There are 3 issues before this court. 1, whether plaintiff met her burden in submitting sufficient evidence to support her loss of chance theory of recovery, and she did. 2nd, if plaintiff did meet her burden, whether plaintiff was entitled or had a right to have the jury instructed on her theory of the case, and case law establishes that she did. And if plaintiff had that right, did the trial court abuse its discretion in denying plaintiff an opportunity to have the jury instructed on her theory of the case? Before I go further with these issues, I would like to correct some misstatement of facts presented to this court. First and foremost, even if the court applies the Borowski analysis as averred by counsel, this manufactured benchmark of 50%, the loss of chance doctrine would still apply, especially for this reason. There was some testimony that plaintiff, more probably true than not, would have survived had she received the antibiotics early on. But there was very definitive and clear testimony that after plaintiff coded the first time, just after 4 o'clock in the morning, she lost her ability to survive. So she lost that ability after 4 a.m., even if antibiotics had been administered. Counsel has represented to you before this court that this viral theory is what the problem was. Well, we know that that's not true, and we know definitively that that's not true. We know that it's bacterial. How do we know that? Because the evidence submitted to the jury proved that that was so. When Jill was transferred to the intensive care unit, after she coded, what happened? The doctors at Mercy properly diagnosed her with sepsis and administered the very same antibiotics plaintiff averred and argued at trial should have been administered when Jill reported to the court on March 16, reported to the emergency room on March 16, 2017. So those antibiotics that were administered after Jill coded in the intensive care unit, those antibiotics, the effectiveness was lessened. The effectiveness was lessened because by that time, Jill was in multi-system organ failure. What did that do? That decreased the ability for her body to properly perfuse and get the antibiotics to the areas that it needed to be. If Jill truly had the condition of viral infection or viral sepsis, then counsel would be right. No antibiotics would be needed. Obviously, that's not true. Dr. Subramanian administered the antibiotics, but it was too late because by then, Jill coded. So this is truly, under any standard, a loss of chance survival. And plaintiff's experts, while early on did say, had she been given the appropriate treatment, more probably true than not, she would have survived, but she lost that ability to survive. Shortly after 4 a.m. on March 18, 2017. Jill presented to the emergency room not once, but twice. They had ample time to get it right. When she presented to the emergency room the first time, she was symptomatic of sepsis, and plaintiff's expert testified that it's more probably true than not that she had 2 of the 4 criteria of SIRS the first time. Jill returned the second time. I would say the first time she sat in the emergency room in the waiting area 4 hours. She returned the second time more symptomatic. By this time, she was short of breath, she was tachycardic, her blood pressure was a problem. They let her sit this time almost 5 hours. When she finally made it to the emergency room, they did nothing more than give her pain medication and IV administration of saline. Now, counsel said, and I'm sure in error, that Dr. Jones or Dr. Heinrich gave her IV antibiotics. He did not. Dr. Arwinker, the attending for the second emergency room visit, clearly testified. He read the record, he knew while Jill was there, but yet he did nothing. At 1 o'clock in the morning, when they received the diagnostics, Jill was in fulminant pulmonary edema, her condition continued to deteriorate, they did nothing. They gave her pain medication and IV. They transferred her to the observation unit, she codes. At that point, if at no other point, there's clear testimony to a reasonable degree of medical certainty that she lost her ability to survive. So that's why we are here, to address that issue. Now, in support of his...
Of course, counsel, I mean, you were allowed to present evidence on this to the trial court. That's not an issue. You were allowed to argue these things to the trial court, correct? I mean, the issue is whether or not the instruction should have been given.
That is true, Your Honor.
So this instruction, you know, we're not looking at the issue of whether or not, in general sense, a loss of chance instruction is appropriate in Illinois at some point in time. We're looking at this particular instruction. Now, there's a couple things with this instruction. I mean, it arguably assumes a bacterial infection. It arguably eliminates the requirement to prove legal causation per Lambie. And it appears, at least on its face, to be way more expansive than any of the instructions that I read in the amicus brief. So if you could address those 3 things for me, I would really appreciate it.
Yes, Your Honor, thank you. I would very respectfully disagree with the court for the reasons
Well,
that
I
I'm
said
about.
arguably, that's why
Okay.
I'm not arguing the case for them. I'm saying it arguably assumes these things, and it appears to be more expansive. So
Thank you, Your Honor.
I'm not arguing for them.
Yes, Your Honor. The instruction says if you find, not when you find. So nothing is implicit in the instruction. Either way, it gives the jury the opportunity to make a choice. And it says to the jury, if you find these things, then you move in this direction. So it's not expansive in that regard. It does not expand the, just let me take a step back. Plaintiff's argument was not that the loss of chance instruction should be given in lieu of the traditional proximate cause 1501 instruction. So the 1501 instruction held plaintiff to the traditional burden to prove her case to a reasonable degree of medical certainty, and that the allegations alleged caused harm. So that remained preserved, that remained intact. This was an additional instruction. It was a clarifying instruction. That's all it was. That's something that this court has recognized over the years. We have many instances where 15.01 instruction is given, and then we give a clarifying instruction. We give the clarifying instruction because jurors are lay people. They're not trained to parse out these nuances. So we have the 1501 instruction, which talks about natural and probable and in the normal sequence of things. Jurors are not trained to parse that out. Jurors cannot look at that and say, oh, I understand that natural and partial and probable, oh, that means lessen effectiveness of treatment. Not so. And because this court has recognized that in prior cases, they have always given additional instructions, such as increased risk of harm, such as an instruction on aggravation of pre-existing damages, such as loss of society. These are all elements of damages that it's grounded in Illinois jurisprudence, where a jury will get additional instructions to clarify. So that's all that was happening here. At no time did plaintiff suggest, intimate, or request that a 15.01 instruction should not be given. All we wanted is the jury to be clear. And yes, to the court's point, the jury did hear the evidence. Plaintiff met her burden. And then plaintiff got to the door and the jury couldn't consider it. So yes, and the jury is properly instructed that what the attorneys do, what the attorneys say, that's not the evidence. So yes, we did get that opportunity, but when the jurors went back to the deliberation, there was nothing before them that permitted them to even consider loss of chance. There was nothing before them that even had the words loss of chance. I mean, that would be analogous to providing this court with a response brief, and when you ask for the opening brief, we say it's implicit in the response brief. No, that's not right. The purpose of a jury instruction is to inform the juries on the issues presented, the law to be applied, and the facts that are required to support that theory. There is nothing the jury did not receive any instruction whatsoever in terms of the issues related to loss of chance. The jury did not receive any legal principles regarding the loss of chance theory. The jury was not advised on plaintiff's burden for the loss of chance theory. This is really important. If for no other reason, this reason as well. The defense got up and argued. It was Jill's day to die. She would have died anyway. No matter what happened, she would have died. The jury was not made aware that plaintiff did not have to prove a better result, that was not necessary. The jury was uninformed. So when the jury rendered its verdict, it was an ill-informed verdict, unsupported by the law as far as loss and chance, and they had no idea whatsoever was required by plaintiff to support a loss of chance theory. So plaintiff was greatly prejudiced in that regard. Defense talks about these litany of cases. To the court's point, well, the court didn't say this, but I'll say this. Longevity doesn't make it right, it just makes it long. And it does not mean that it's not time to address it. Of the cases cited by the defense, 9 were pre-Holton. The next 9 that were cited by the defense were post-Holton. But those cases dealt with sufficiency of the evidence. That is not before this court. There has not been any challenge at any level of proceeding that plaintiff did not meet her burden. So that issue is not before the court. That leaves 5. Of the 5 cases, we have Henry and we have Lemby that said that the jury instruction was confusing and misleading. That's not what the trial court said. And it's only before this court that defense is now making that. We have Santera, who who didn't bother to analyze the instruction itself, but simply adopted the prior cases. We also have Greckengord, who distinguished Bailey and said we need not go there. This is not that kind of case. This is the very first time that the specific facts of this case has been before any court, including the appellate court. And in this instance, under the facts of this case, the appellate court got it right. They found that the trial court abused its discretion. And we, my partner and I, we understand and we acknowledge that this court gives deference to the decisions made by the trial court. But it is reasonable for that deference to be measured against the decision-making process of the trial court. And to understand that, we need only to look at the evidence. Is there any evidence anywhere that the trial court's decision to reject the loss of chance doctrine was well-reasoned, was rational, was non-arbitrary? There's no evidence of that. Is there any evidence anywhere that in reaching its decision, the trial court employed the tools that were available to it, such as the parameters identified in Illinois Supreme Court Rule 239, which this court set? No. Is there any evidence that the trial court applied the legal principles espoused in Holton? No. There's no evidence. So what we're left with is that the trial court's opinion was arbitrary. It was not well-reasoned. There's no evidence. It was not rational. There's no evidence. It was not. And it defied the evidence presented in this case. And so for that reason, we know that the appellate court got it right. And I will go one step further and respectfully say that the trial court did not exercise the inherent discretion it was given. It made no assessment whatsoever of the appropriateness of plaintiff's instruction. It simply said it's a non-IPI instruction. That's it. That's all. And by doing that, the trial court rejected plaintiff's instruction because of the category, not of the content. It never assessed the content. So the appellate court was obligated.
Counsel, time.
My apologies. And I have to apologize to my colleague who did not get an opportunity to argue informed consent. My apologies. If there are no questions for the court, I will take a seat.
Your counsel does have time.
Thank you so much. I appreciate it. Thank you. Thank you. Thank you, Your Honors.
Mr. Streckley?
May it please the court. Good morning, Your Honors. It still is the morning. I'll try to be brief with my comments. My name is Robert Strelecki, and I represent, along with Vivian Varnado, the plaintiff appellant. I'm addressing the issue of informed consent. And I would suggest this in contrast to what my colleague on the other side has said. This is clearly a case that demanded an instruction on informed consent. This narrow interpretation that the defendant appellant is taking, that somehow informed consent cannot apply unless there is a surgical procedure or a course of treatment involved, and that somehow the facts of our case did not warrant giving such an instruction. Clearly, the evidence in this case is that on the morning of March 12th, Dr. Jones, the defendant, was attempting to obtain the informed consent of Jill Milton Hampton to remain in the hospital for further evaluation, further testing, and potentially further treatment. And we just have to look to the facts as they were presented, not just by the plaintiff's side of this case, not just by our experts, but by Dr. Jones himself and defendants' 2 emergency medicine physicians.
Counsel, we tend to view informed consent in the situation where someone doesn't have enough information and then had some kind of a procedures done and it wasn't. This is kind of the negative of that, isn't it?
In a sense, it is. But the importance of informed consent is to properly inform a patient so that patient can make a legitimate decision about his or her own course of treatment and health.
Have you been able to find any cases that are like that, that we found?
Well, that not precisely on that point. However, it's expansive. If you look at the cases, for instance, the Doe case that we cite in our brief, here was a patient undergoing a kidney transplant and was not informed of the HIV positivity of the donor kidney. You know, that had nothing to do with the treatment itself or whether the patient was making the right decision. It was a worry about future risk from this disease process, and it wasn't a particular procedure. I think what's key in this case is that Dr. Jones himself admitted that he had the concern because of Jill's persistent tachycardia, her consistently elevated heart rate, that she was suffering from something else, a red flag, something else was going on. He considered the possibility of a pulmonary embolus, he considered the possibility of a gastrointestinal bleed, and he considered the possibility of an infection, including sepsis, which was the cause of death, not toxic shock syndrome as was discussed. Sepsis, a systemic infection. He had these concerns in his mind, yet by his own testimony, he did not tell Jill of his concerns, and she made the decision to leave the hospital. Our emergency medicine expert, Dr. D'Ambrosio, as well as the 2 defense emergency medicine experts, Drs. Ward and Courtney, unequivocally stated that if a physician has concerns about life-threatening conditions, the physician has a duty to disclose those to the patient. In fact, Dr. Ward, one of defendant's own experts, said if Dr. Jones had these concerns and did not advise the patient, he would have a hard time defending Dr. Jones. Well, lo and behold, that's what Dr. Jones testified to, that he had these concerns and he did not inform Jill of those concerns. He did not provide Jill with sufficient information to allow her to make an informed decision and give informed consent. Well, I'm done. Thank you for your time. Thank you for consideration.
Thank you, Mr. Strelak. Mr. Walsh?
Thank you. Thank you, Justice. Just a quick couple of rebuttal issues. This court's absolutely right. The instruction on informed consent, if you look it up under O2, it has the elements and it has a line, and underneath the line it says procedure. It doesn't say suppositions by the doctor, potentials by the doctor, what might be going on with the patient. It says procedures. And all of the cases that dealt with informed consent that have been cited by everybody in this case, including the appellees, it talks about informed consent for a particular surgery or procedure. The Doe case, for example, actually the patient didn't have HIV, but apparently he was in an environment where HIV was a risk that should have been conveyed to the patient, but that's pursuant to the transplant rules. before the particular plaintiff accepts the transplant or not. Once again, that's part of the treatment, the surgery. The other cases we talked about in our brief, they're all surgeries, much like TPA given to a patient who you suspect having a stroke. You talk to the patient about giving TPA because there's a 6% chance of death. You're already past the what's going on here stage. You're in the here's my diagnosis, here's my treatment. And that's where informed consent plays. And in this particular case, there was no definitive diagnosis. And actually, counsel raised an issue. If I use the word IV antibiotics, no, that's wrong. IV fluids were given to Ms. Jill Milton Hampton on the morning of the 17th by Dr. Jones.
Yeah, but in a simplistic way, requiring or requesting that the patient stay in the hospital is for treatment, isn't it?
It's for further assessment because Dr. Jones wanted to dig deeper to find out what's going on with the patient. So, Justice, you're absolutely right. It's not necessarily a treatment. It's a let's find out what's going on. So they're assessing and trying to figure out what's happening with the patient. GI bleed was a possibility. PE was a possibility. Actually, those were addressed the next day when a CT scan ruled them both out. But the bottom line is the plaintiff is trying to impute a knowledge that the doctor does not even have to say, you have to tell her if you leave, you're going to die. If that's the standard we're going to be asserting on physicians when patients are leaving the hospital, I don't know how to defend doctors. So we're going to have to tell every single patient who doesn't want to be there, who's adamant about leaving, oh, by the way, you leave, you could die. There was no AMA, against medical advice, rule or issue that he gave this patient because he wanted to keep the door open. An AMA is adversarial, and so a patient doesn't want to come back if they're AMA'd. They're going to come back and say, hey, if you're no better or worse, get back in here. If you're not going to stay, we want you to stay. And Judge Lyons understood this and said informed consent doesn't apply in this case pursuant to the modified instruction that was offered by plaintiff. He said, put it in the work it out, put it in the jury instructions under issues. If you can't work it out, let me know. We worked it out. Plaintiff put in her instruction. Proximate cause instruction was also given. And it basically said that Dr. Jones, did he deviate? Was he negligent in not instructing the patient on the possibilities of what's going on? That was the instruction. That's what plaintiff agreed to. That's what we did. That's what we submitted. The proximate cause instruction is fine. And so there is no harm with respect to denying a modified informed consent that doesn't apply. And as far as the loss of chance theory that plaintiff has been espousing, the constructs of it don't fit what she's looking for. Loss of chance is being used vaguely and generally by plaintiff's counsel in this particular case. Loss of chance is a theory that they argued with respect to their doctors, saying that you deviated by not giving the patient antibiotics. That's their theory. Also, the instruction, Justice, as you mentioned, that they proposed was incredibly vague. It said sepsis. Well, there's two different kinds of sepsis. There's ones that can be caused bacterially, and there's ones that can be caused by a virus. And so what they're doing is they're grabbing both causes and saying, hey, that's a proximate cause, when that's not the case. You can't treat a virus with an antibiotic, as we unfortunately know over the last 2 years. For those reasons, Your Honors, I request that you reverse the First District Appellate Court's ruling about the abuse of discretion by Judge Lyons. He did not abuse his discretion. He was well within it and followed the law. And there's no reason to remand this case. Now, as an aside with the Holton case, as this court did, instruction or maybe direction with respect to what is and what isn't a lost chance case may be helpful for litigants in this state to limit and instruct when it's appropriate, and in this particular case, when it is not. I appreciate your time. If anyone has any further questions. Thank you very much.
Mr. Walsh. Case number 126748, Jill Bailey versus Mercy Hospital and Medical Center et al., known as agenda number 17, will be taken under advisement. Mr. Walsh, thank you for your argument this morning. Mr. Struckley, thank you. And Ms. Trevor Bernardo, thank you very much for your arguments, actually this afternoon. And